Good afternoon, everyone, and welcome to the launch of the Council's report on sex offences in Victoria. I'm Ari Freiberg and I'm Chair of the Sentencing Advisory Council, and I'm joined today in giving this presentation by the project team, Paul McGorry, who's our Manager of Legal Policy and Community Engagement, and Octavian Simu, our Legal Policy Officer. And just for the record, this report wouldn't have been possible without the work of our senior statistician, Zombor Bathi, who couldn't join us for today's launch. And before we start today, I'd like to acknowledge the traditional owners of the land on which the council is located, the Wurundjeri people of the Kulin Nation. I pay my respects to their elders, past, present, and future. Now, we intend to keep this presentation relatively brief, so in the interest of time, we won't be having a Q&A session, but feel free to email Paul with any questions that you've got. His details will be up on the last slide. And for those who don't need to take notes, there'll be a recording and an uploading of this presentation on YouTube a bit later on. Well, let's begin by looking at exactly what prompted the council to investigate whether there have been any changes in the sentencing of sex offences over the last decade. Now, first, because the research suggests there's a discord between how sex offences are sentenced and how the community expects them to be sentenced, the research indicates that there is a difference of opinion. In fact, recent research by Tasmania's Governor, Kate Warner, has shown this to be true in Victoria and even elsewhere, and that the type of offence that most people were likely to consider to be too lenient was for sex offences, especially child sex offences. A bit earlier than that, the council had done some research about people's attitudes to sentencing certain offences. Rape and child sex offences were considered to be among the most serious offences, in fact, second only to murder. So what we see here is that the types and lengths of sentences imposed for sex offences, and in 2009 and 2016, we looked at sentencing practices for sexual penetration of a child under 16 and under 12 respectively, and found sentencing practices were too low and too constrained. And we recommended that there be a guideline judgment about these types of offences as a way of shifting those sentencing practices. Alas, that hasn't happened yet. Now, the Victorian Court of Appeal has also been alive to these issues, and in 2009, they found that in respect of sexual penetration of a child under 10, the range of sentences being imposed at the time were difficult to reconcile with the maximum penalty for the offence. In the same year, they raised questions about the adequacy of sentencing for the offence of persistently sexually abusing a child under 16. And in 2016, the High Court handed down its landmark judgment in the case of DPP and Dalgleish, in which the court found that sentencing practices for incest revealed an error in principle in that they were not a proportionate response to the objective gravity of the offence, and nor did they sufficiently reflect the offender's moral culpability. So this growing concern about the sentencing of sex offences in Victoria acts as a backdrop to three significant legal reforms. In March of 2017, legislation came into effect classifying certain offences as Category 1 offences. And now that means that most serious offences, including rape, incest with a child, sexual penetration of a child under 16, these offences may only receive a sentence of imprisonment. And for these offences it's effectively a mandatory sentencing scheme, although the mandatory minimum period is not specified. And then in October 2017, the High Court delivered its judgment in Dalgleish, and the High Court shared the Court of Appeal's view that I mentioned a moment ago, that sentences for incest with a child needed to increase, but says that sentences should increase immediately and not gradually. And finally, in February of 2018, legislation came into effect that introduced standard sentences for some of the most serious offences, most of them sex offences. And that was a product of one of our previous reports on sentencing guidance. A standard sentence is another numerical guide or yardstick for the courts. And the then Attorney General, Martin Pakula, said in November of that year that this scheme was expressly designed to increase sentences, including for rape and sexual offences against children, to bring them more in line with community expectations. And so in the light of these changes, we set out to get some early insights as to the effect that these changes have had on sentencing offences. And we looked at them over the last decade. So what effect have these reforms had? And I'll hand over to the project team to take you through what they found. Octavian.
Thanks, Ari, and good afternoon, everyone. So first, just for a bit of context about what we'll be talking about today, this slide shows us how many sex offences were recorded by police and how many were sentenced by courts during our research period. In total, there were over 84,000 sex offences recorded by police in that 10-year period. And in the same time frame, there were about 15,000 sex offences sentenced by courts in around 5,500 cases. Consistent with just about all research on sex offending, 97% of sentenced offenders were male. Looking at just those 84,000 recorded sex offences, this slide shows us how many were recorded each year from 2010 to 2019. And working our way up each column, the green at the bottom represents the number of rape offences, the yellow represents sexual penetration of a child under 16, the blue represents sexual assaults committed against adults, the orange represents sexual assaults committed against children, the grey represents incest, mostly against children, but also between siblings. And the purple, which isn't very visible here because of the low numbers, that represents the offence of persistent sexual abuse of a child under 16. The key takeaway from this graph is that there's been a significant increase in sex offences recorded by police during this period, and this is largely because the number of rapes and sexual assaults of adults, that's the green and the blue bars here, each roughly doubled. The council spoke to a number of stakeholders in this space to seek their insights, and they suggested that the increases in recorded offences were likely the result of increased awareness in the community about what constitutes sexual offending, coupled with a greater willingness and confidence to come forward and report crime. That's certainly consistent with the research released just earlier this month by Boxar in New South Wales, that increased media attention on sexual assaults caused a significant increase in reports to police in March of this year. Meanwhile, in the same time frame that we saw that significant increase in recorded sex offences by police, there was no corresponding increase in the number of sex offences sentenced by courts. As to why this might be, the people we spoke to suggested there could be a number of factors at play here. It may be that sentence charges are increasingly representing multiple instances of each offence type. For example, a single charge may now be more likely to represent multiple rapes. It could also be due to an increase in people reporting historical offences, which are generally more difficult to prove and less likely to be successfully prosecuted. What this graph also shows is that the majority of sentenced sex offences were committed against children. That's at least 55%, but likely even as high as 64%, given that the majority of incest offences are committed against children. Just one final point on these numbers. When comparing the number of each offence type recorded by police and the number sentenced by courts, a striking result emerges. Rape was the most common offence recorded by police at almost 23,000, but aside from persistent sexual abuse of a child under 16, was the least common offence sentenced by courts at just over 1,000. Understanding why this might be the case is beyond the scope of our research, but it may be something that warrants further investigation. So what kinds of sentences did sex offences receive? The majority received what's known as an immediate custodial sentence, one that requires the offender to spend at least some time in adult prison or juvenile detention. Incest with a child, for example, received an immediate custodial sentence 99% of the time, followed by rape at 96%, With a few minor exceptions, these rates did not change much over the 10-year period. Incidentally, the 4 top offences on this graph are also now all Category 1 offences. They already had very high imprisonment rates, as we can see here, but that'll grow even higher now that they're Category 1 offences. Of course, this graph begs the question, who are the people not receiving custodial sentences for these serious sex offences? We looked into those cases to get an idea of the circumstances that were leading courts to impose what might either be seen as a lenient or a merciful sentence. In our full report, we present case studies for each of these offences, which can no longer receive such a sentencing outcome. The next slide contains 3 of those case studies. They contain details of real cases of sex offending, and if these details might make you feel uncomfortable and you'd prefer not to hear them, I'll pause for a moment to give you a chance to mute your device and speakers, or just step away for a few minutes. That content should only go for about a couple of minutes and is limited to just the one slide. So once you see me flick to the next slide, feel free to return to the presentation. Now, I know it's a PowerPoint presentation faux pas to read off the slides, but I'm confident you'll agree that the details of these case studies are important to understanding the context underlying the sentencing outcomes imposed. Outcomes such as a 2-year community order for persistent sexual abuse of a child under 16. That's the box on the left. The 19-year-old offender began a sexual relationship with the 15-year-old victim, believing she was 16. She told him her real age a month later, but they continued their relationship. He made full admissions to police and pleaded guilty. He was assessed as having an IQ of 75 and was on a disability pension. He had no prior convictions and had been engaging well with drug counselling. Next, in the middle box, a 3-year community order for sexual penetration with a child aged under 12. The offender also pleaded guilty to 2 charges of indecent acts with a child. He would occasionally sleep over at the house of 2 boys, one aged 11 and the other 12. The sexual penetration charge related to putting the 11-year-old's penis in his mouth, while the indecent act charges related to him masturbating both victims. The court noted the offender had an IQ, placing him at the bottom 2% of the population. He also suffered from a rare physical condition, resulting in a loss of muscle control that caused him to fall. The court concluded that because of the offender's intellectual disability and rare physical condition, his guilty plea and lack of prior sexual offending, and his family support and his suitability for a justice plan, something only available to offenders with an intellectual disability, a prison sentence would not only have been unusually more burdensome for this particular offender, but also unnecessary. And for the third example on the right, the offender received a 3-year community order for incest with a child under 18. In fact, this was the only case in the whole 10 years in which a sentence other than immediate custody was imposed for incest with a child. A decade prior to sentencing, the offender digitally penetrated her daughter at the instigation of her husband, who had been abusing both of them. The offender had a traumatic upbringing and a low IQ. She agreed to testify against her ex-partner, and at the time of sentencing, she had sole custody of her 10-year-old son and no extended family to care for him if she were imprisoned. These are the sorts of people that would now need to receive imprisonment under Category 1 classification. And it's obviously challenging to capture all of the complexities of a case for which a judge has passed sentence. But these case studies provide vital context for the statistical findings. They also raise an important implication for Category 1 offence classification, that while such a restriction may achieve its intended aim of ensuring that serious sex offenders don't escape prison, in other cases, it poses a real risk of injustice. And that can have consequences for the community more broadly. As the Council has stated clearly, since as early as 2008, mandatory and other prescriptive schemes are unlikely to achieve their aims. To the extent that such schemes achieve some of their aims, the research indicates that they're achieved at a high economic and social cost. Given that the 72 Category 1 offences we analysed all received quite lengthy periods of imprisonment, it's doubtful that this mandatory sentencing scheme has yet had much of an effect. There may soon be a case, however, where a judge is put in an awkward position of having to imprison someone for whom imprisonment simply isn't appropriate. I'll now hand you over to Paul for the remainder of the presentation.
Thanks, Octavian. So we're shifting now into looking at the effect of standard sentences. As Ari mentioned, what standard sentences do is give judges another yardstick they have to take into account when sentencing certain serious offences. They already have the maximum penalty, which is the longest term of imprisonment they're allowed to impose, and that's designed to reflect how serious Parliament, on behalf of the community, considers that type of offending. A standard sentence falls somewhere in the middle, representing what's called the middle of the range of objective seriousness, meaning it takes into account all those factors that make the offending itself more or less serious before we look at the offender's personal circumstances. The standard sentence for each of the sex offences we looked at is exactly 40% of the maximum penalty. For the 4 offences with a 25-year maximum penalty on the left, rape, incest with a child, sexual penetration of a child under 12, and persistent sexual abuse of a child under 16, the standard sentence is 10 years prison. For sexual penetration of a child aged 12 to 15, which has a 15-year maximum penalty, the standard sentence is 6 years. And for sexual assault of a child, which has a 10-year maximum penalty, the standard sentence is 4 years prison. Now, in addition to this new numerical guidance, courts are also, when sentencing someone under the standard sentence legislation, not allowed to take into account how people were sentenced in cases where the standard sentence didn't apply. This effectively frees them from having to consider sentencing practices that Parliament has considered too low and in need of changing. So the question is, have standard sentences increased prison sentence lengths as intended? It's still early days, and we're talking about relatively small numbers for some of these, but as you can see on this slide, our research suggests they are. For each of the sex offences covered by the standard sentence scheme, their average prison sentence in 2019, so that's the green bars, was longer than it was for offences not covered by the standard sentence scheme, that's the blue bars. For example, looking at the offence of rape in that second set of columns, the average prison sentence in 2019 was over 6.5 years long when the standard sentence applied, but a year shorter when it didn't. And this was consistent across every offence we looked at. Average prison sentences were uniformly longer when the standard sentence applied than when it didn't. The only exception is that there were no charges of persistent sexual abuse of a child under the standard sentence scheme in 2019, but we have started to see some cases come through since then. What all this tells us is that standard sentences seem to have achieved what they sought out to do, and we'll be monitoring closely to see whether this trend continues. Our next point of inquiry was to ask what effect the various Dalgleish decisions by the Court of Appeal and High Court have had on sentencing the offence of incest with a child. You see, Victoria's developed an approach that seems to be quite unique in Australia, whereby the Director of Public Prosecutions brings a case to the Court of Appeal, and the court undertakes an extensive review of how a certain type of offending is sentenced, using statistics and comparing the facts of various cases. If they find that the way the offence is currently sentenced doesn't reflect the seriousness of that type of offending, they make what's described as a call to uplift sentencing practices, meaning judges should start imposing longer prison sentences. They did this for aggravated burglary in 2011, causing serious injury by glassing also in 2011, drug trafficking in 2017, and a number of other offences over the last decade. Most importantly for our purposes, in June 2016, the Court of Appeal heard a case in which a man had impregnated his 13-year-old stepdaughter. The original court sentencing that man gave him a sentence of 3.5 years imprisonment for that offence and 5.5 years overall because there were other offences in the case as well. The Director of Public Prosecutions appealed that sentence as too low and argued that it was because the sentencing court was looking at this case through the lens of other incest cases where worst case offending was only being given sentences in the range of 4 to 7 years. The Court of Appeal agreed with the Director and said courts should stop feeling constrained within this narrow range when sentencing incest, and that 4 to 7 years should stop acting as a ceiling. Courts should instead start imposing sentences that more proportionately represent the gravity of this kind of offending. What the Court of Appeal didn't do in 2016 was increase that particular offender's sentence, because they said he had pleaded guilty on the understanding that he would receive a penalty like those imposed in similar cases. The Director of Public Prosecutions then successfully appealed that decision to the High Court, who said offenders should expect to receive sentences according to law, not according to their expectations. And so the case was sent back to the Court of Appeal for resentencing. 2 months later, they increased his sentence for incest by 4 years, from 3.5 years prison to 7.5, and also increased his overall sentence from 5.5 years prison to 9.5. So what effect did all these cases and calls to uplift have on sentences for incest with a child? There was a relatively stable range for average prison sentences for this offence between 2010 and 2015, ranging from 4 years to 4 years and 8 months. We then see quite a big jump in 2016, which also happens to be the same year the Court of Appeal issued its first Dalgleish decision. We then see another even bigger jump in 2019. Now, standard sentences account for some of that 2019 increase, but there is still a significant jump that year that seems attributable to the ongoing influence of the Court of Appeal and High Court Dalgleish decisions. This offence of incest with a child or stepchild was the offence type subject to the most reform during our research period, and it also happened to be the offence experiencing the greatest shift in sentencing practices. While it's never easy to disentangle the many complex factors that can affect sentencing practices year on year, these results strongly suggest that each of the reforms have, individually and together, caused a considerable shift in how incest is sentenced in Victoria. To a lesser extent, we've also seen a shift in the average prison sentence for rape. For years, the average prison sentence has hovered quite consistently around the 5-year mark. What we can see in 2016 and 17 is that this average has jumped about 20% and now hovers closer to the 6-year mark. What we can't tell in this research is whether this was due to an overall change in how rape offences are sentenced in Victoria, or whether it's due to another one of those uplift cases I mentioned. In 2017, the Court of Appeal reviewed sentencing practices for rape by digital penetration and said that sentences were well below what is necessary to reflect the objective gravity for that offence and the moral culpability of the offender. Now, that case happens to coincide with the increase we can see in the average prison sentence from 5 years to 6 years. Whether it directly caused that increase is something that would need to be investigated in future research. Now, that's it from us for this afternoon. I encourage everyone here to download copies of both reports from our website. There's a longer and more statistical report about the 3 sentencing reforms on the left, and there's also a shorter, less statistical report about sentencing more generally with case studies on the right. And they both have the findings we've talked about today, as well as much more. If you have any questions arising from today's presentation, please feel free to get in contact. You can send an email to me using the email address here on the screen. Please feel free to take a screenshot, or you can get in contact through our website. Otherwise, we'd like to thank everyone who took the time out of their busy day to attend today's session, and we hope you all have a lovely afternoon.